Welcome to this free immigration help channel. Today is March 15th, 2023, and we are starting volume 32 of me going through your comments, through your questions. As you guys can see, I have all of them open in front of me and answering them one by one. So without further ado, let's start with the very first one. First comment from Pauline, Liverpool, Thomas. What if you did not receive a letter from USCIS requesting more evidence for your I-130 and the time has passed for submission when you discover that information in your account? Excellent question, Pauline. I would say it really depends on what kind of evidence it is. If you can follow up on this video, if you can post in the comments what kind of evidence it is that you're referring to, I'd probably be able to give you a little bit more information. But basically, you have to understand that whenever it comes to the USCIS part of the process, whenever it comes to the family petition, petition for alien relative, I-130, basically, USCIS on their side, they try to establish your eligibility to submit this petition and invite the alien relative, basically, into the country. And then once it is approved, it's transferred to the NVC for further processing, where they actually work to establish the eligibility for the person to actually come into the United States. So here, on the stage one at USCIS, it's just the eligibility for you. And then it is the eligibility for them to actually come in at the NVC. So the reason why I'm saying it is because whenever it comes to the USCIS, I would say it's a little bit simpler process whenever it comes to the I-130 petition compared to the NVC. So that's one of the reasons you might not have gotten the request for that evidence, maybe because they just really don't need it at that stage just yet. Now, again, it really depends on what kind of evidence it is. That's why I said, if you post it in the comments, it would be a little bit easier for me to kind of go over it. But if that's something, if they haven't requested it, I wouldn't worry about that too much. Now, you can submit and send them by mail. Just make sure you're mailing the copies with a little cover letter that has, your address, their address, case details, the date, basically just a standard kind of a format, professional, polite. Hey, dear sir or madam, I'm sending this evidence in addition to my case because I was not able to submit it initially. If you want, you can do that, but depending on what kind of evidence it is, I wouldn't worry about that too much. All right, let's move on to the next comment from Freddy Escobar. Thanks. You're very, very welcome, Freddy. Thank you for watching. Moving further to comment from Deluxe. Actually, you know what? I completely forgot. I have to do this. There we go. And also this. All right. First of all, thanks for detailed comment from Deluxe Cabinet. First of all, thanks for detailed, easy understanding videos. You're very welcome. Thank you for watching. So, quick question. I want to apply for my parents to come to US, but they have two nationality. Which passport should I upload? The passport where they're born, or it doesn't matter? Thanks in advance. Excellent question. I'm glad this was brought up because we did not talk about this before. So whenever it comes to double citizenship, definitely use the address, the physical address where they live, so whichever country they live in, because on the application they ask regardless where the person, whether the petitioner or the beneficiary were born. So you're gonna put that information regardless in the thing. But one thing that I want you to keep in mind, just in case, probably not the case, but just in case, the chargeability area. Okay, so as long as one of those passports, one of those citizenship does not fall in one of these separate chargeability categories for China, India, Mexico, and Philippines, because these chargeability areas are extra long whenever it comes to the processing. They have some extra delays because the immigration is heavier from those countries. But if that's not the case, then I wouldn't worry about that. Just use the wherever they currently reside, their physical locations. So I'm gonna put this here, and we're gonna go move further to question from Sanjeev. Hello, sir. I've been working under DOD DOS contract in Iraq with USA Army and from India, so now planning to move USA. From India, is there any way I can get job in USA? I'm truck driver or operator. Interesting question, Sanjeev. So whenever it comes to the employment authorization, basically the ability to work in the United States as a, as a non-citizen, as someone who's from another country, you do have to meet certain eligibility criteria. So basically you have to have a certain status in order to be able, or a certain visa, for example, if it's non-immigrant status, right? Non-immigrant visa that allows you specifically to work in the United States of America. So let's say if, for example, because you asked a question on I-129 petition for non-immigrant worker, in that case you have to have an actual employer, a company that is willing to sponsor you, to sponsor your petition to come into the United States and work for them. That's one of the ways you would be able to get a non-immigrant workers visa, and with that visa you would be eligible to get the employment authorization document. I would do a little bit more research. I'm personally not familiar whenever it comes to the contracts with the military, but a lot of times whenever there is a foreign individuals involved working with US military, a lot of times they do have certain benefits. So since you already had a contract with the army, check out that contract, because in that contract there might be a clause that gives you certain benefits, which one of them might be a possibility of you coming into the United States and actually immigrating in the United States. So not just non-immigrant petition, but actual immigration. So I would say look into the contract and see if you can figure out the eligibility, because that's really what it's all about. It's all about the status. All right, let's move on to the next one from Tanya Sultana. Can you help me for expedited, please? My mom applied for my brother. They are under 21. I did one time expedited. NVC's response, no. Okay, Tanya. So I'm gonna ask you a follow-up question. Whenever it comes to the I-130 petition that was submitted for your brother, is the immigrant visa already available for that petition? Because whenever it comes to the expedited processing with the NVC, in order for them to be able to approve it, besides having a good reason to request that expedited processing, the immigrant visa it must be available already for the beneficiary. So if the immigrant visa is not available, if it's still in the backlog and the delay, you're still waiting, then there is no way to request. Unfortunately, there is no way to request the expedited processing. So if you could follow up, that would be great. And also, if you can, if it really is not, if it is already available, right? Also, you have to have a good reason for the expedited processing. So it can't be just, because everybody's waiting. So it has to be a good reason, like, for example, financial hardship, some kind of humanitarian reasons. So if you can follow up with a follow-up comment, that would be really, really helpful. All right, let's move on to the next one from AA Gum. Is there any way we can expedite the case? Humanitarian reason, okay? If it is pending for many years, like 5 years. Oh, that was an asylum. Sorry you're going through this. Let's say something unfortunate sexual abuse happened to that person and undergoing some legal case and therapy. Can we expedite the case in such circumstances? First of all, sorry that you're going through this. This is one of the things that I put on top unfair procedures by just Department of Homeland Security in general, just everyone who's involved in the decision making whenever it comes to the immigration reform, because whenever it comes to the asylum cases, basically what kind of a recent decision that was made, the newer asylum cases that are being submitted now, they are processed faster. They are scheduled to interview just as on the first come first served basis. However, if you have applied before a certain date, you really are still waiting basically for the new cases to be processed, which is ridiculous. Honestly, it's completely dumb. I have no idea who came up with this idea, and came up and said, "Hey, how about we do that?" Because that person is just, I don't, I don't have a polite word to describe whoever made this decision and whoever supported this decision. But unfortunately, that is the case. Now, whenever it comes to the expedited request, you can definitely submit the expedited request. And in your situation, I would recommend sending these expedited requests just on a regular basis. You send it. If you don't hear back within like 2-3 weeks, you send another one. And then you send another one. And then you just keep requesting and keep requesting. And I would also recommend you looking into the video that I've made on this channel. It's how to submit the complaints. Basically, you're looking at the chain, and you're looking who's higher up on the chain, and you just, if these guys don't respond, you go further up, and then you go further up, and then you request help from your state senators. You request help from local elected officials. You just keep going, and you keep fighting, because unfortunately you're in a position of disadvantage, unfortunately. So keep submitting them, and yes, you can. Just look up, for example, the video that I've made on I-130. Submitting the requests to the NVC for expedited processing is going to be exactly the same format. Basically, it's just a cover letter from you, obviously all your information, to obviously whoever you're sending to. Let's say if it's USCIS, let's say if it's Ombudsman's office, let's say it's Board of, whoever it is that you're sending to, or the Senator's office, whatever. And then a detailed cover letter saying, "Hey, dear sir or madam, my name is blah blah blah, date of birth is this is my case number, I have applied for asylum, I've been waiting for 5 years, there is a serious issue, humanitarian reason, I'm requesting," you're describing all of that stuff in the cover letter. And also, if you can attach at least one piece of, if you can, supporting documentation that shows that the humanitarian reason that you're requesting based on, and in your case, you're definitely gonna have that. Attach that and just send it to, I'm telling you, USCIS, Senator's office, any elected official that you can find that is willing to. Just call their office. Call their office and say, "Hey, I have a pending case. I was wondering if your office can help me." And then on your behalf, they can also send a request to the USCIS, to the asylum office. And that's another thing that you would want to probably look into, your local asylum office, where your case is. Send it to them as well. Sorry you're going through this, and I really hope that you can get this moving along. All right, let's move on to the next one from Red Number. "Hey sir, in what year January 2011 file will get welcome letter for I-130? Appreciate your reply." Okay, Red Number, so if you can follow up with a comment on what kind of category it is in, I would be able to give you a little bit more information. Now, because you're saying January 2011, I'm thinking it's probably either F3 or F4 categories, third priority or fourth priority. The reason why I'm saying is because Visa Bulletin, if you look at the only thing that is older than 2011 is the F3 and F4, which is November 2008 and March 2007, which is pretty close to each other. So if it's F3, F4 categories and you have submitted in 2011, you're looking at about 3-4 years, depending on which of these two categories you're in. But again, if you can follow up specifically which category it is, I would be able to give you a little bit better estimates. Now keep in mind though, whenever it comes to the welcome letter, because the welcome letter is basically kind of inviting you to the NVC portal to become documentarily qualified for the petition, you might get it earlier than that. It's really, I've noticed with the cases, sometimes you get the welcome letter before the visas are available, the immigrant visa is available. Sometimes NVC, they wait for the closer for the visa to become available, and sometimes they wait for the visa to become available to send you that welcome letter. So I'm not sure how they're making this decision, but judging by the visa bulletin, and this is the latest one they have so far, which is March 2023, date of filing, these are the dates that you're looking at. For the F4 category, it's from December 2007, F3 November 2009, F2B January 2017, F2A all the visas are current because there is no cap, and then first priority categories August 2016. So I'm gonna wait for your response. If you can submit the separate comment on this video, and for everyone who's watching, I'm gonna ask you if you could, whenever you're doing a response to my whatever it's answer or question, please put the comment as a separate comment. So don't respond to this here, because when you respond to this, for whatever reason, YouTube does not send me notification and your comment does not appear on my comments, whatever it is, wall or whatever. I'm not sure why, but that's the case. So please, if you can, just write a separate comment. And I should have probably mentioned that earlier. I'm sorry I didn't. But keep that in mind, please. All right, let's move on to the next comment from Vinay Kapoor. PL write about, I'm assuming this, please write about F2B visa prediction. What after I-130 approval? When can I apply for adjustment of status when you are already in USA on H-1B visa? All right, Vinay, great question. So whenever it comes to the F2B visas, we have currently, and F2B is unmarried sons and daughters 21 years of age or older of permanent residence. And currently, whenever it comes to the date of filing, the cases that are, the visas are becoming available for cases that were filed back in January 2017. So there is about 6 years. My math is bad. That's why I'm dealing with immigration law and not any mathematicals. I'm glad I'm not dealing with mathematics. January 2017, so 6 years. About 6 years of delay. So let's see. So you don't specify when your petition was filed. So if you can, also follow up, comment, separate comment. Don't respond to this, please, because this I'm not gonna get notification. So as a separate comment, if you can let me know when that petition was filed, I would be able to give you a little bit estimate, but there is about 6 years of delay. Keep that in mind. So for example, if your petition was filed in 2020, approximately your visa should become available in 2026. Now, moving further to another question that you asked, when can I apply for adjustment of status? I got actually good news for you, because you don't have to apply separately for adjustment of status, because I-130 petition is already for the adjustment of status technically, all right? Not as open as literal, if that makes sense, but technically, once you get that immigrant visa, once you get that status, once your petition is approved, the I-130, once you go through the interview, the medical exam, all that sort of stuff, that's it. You already become a temporary permanent resident, and it's just a matter of few months, really, most of the times, until you get your permanent resident card, your actual green card in the mail. So you don't have to submit any separate adjustment of status petition. So that's a good news. And then also in your situation, since you are already in the United States on H-1B visa, I mean, it's great. You really don't need to worry about anything, because people most of the times, if they're outside of the United States and they have to wait for years, it's a little bit tough. But since you're already here, makes the situation much better. So if you can follow up, that would be great. I'll be able to provide a little bit more details on your case. All right, moving further to question from Madain Yegbikadan. Definitely mispronounced that. I'm very sorry. Invest in the Somali Republic passport. Top advice for everyone. Okay, so that was on the video that I made, the U.S. immigration news updates for Somalia, because there's just few days ago, there was an update, a big update for temporary protected status holders from Somalia. So that's why Madain here says that invest in the Somali Republic passport. Don't do that, please. Don't, that's a joke, okay? Don't do stuff like this. This is not a good advice. All right, but it's a good joke though. I do like it. All right, let's move on to the next one from Fernando Blanco. Hi, my old address is one, but also old mailing address is a PO box. When I change, I should put it in my old address, the apartamento, or the PO box mailing address. Okay, I see what you mean, Fernando. So here's the thing. It depends on who you're changing it with, right? So if you were changing your address with the USCIS, right, you definitely want to, because they had probably most likely your physical address, you probably want to update with the physical address and put the new one, all right, and the new mailing address. Whenever it comes to the USPS, they most likely had in their system your old address, your mailing address, your PO box, because that's where, I mean, the only thing they care about is just sending you mail, all right? So over there, you're probably gonna want to put the old PO box address and then updated new mailing address, if that makes sense. So I'm gonna put that. If it's not clear, let me know. But USCIS, they care more about your physical address, right? And then the new one is gonna be the mailing address. And then whenever it comes to the USPS, they only care about your mailing address. They don't care about your physical address for the most part. So with them, you're just going to be updating the mailing addresses. So basically, whenever they send you something, the mail that they send you is redirected to the correct address. And they see, oh, okay, so it's going to the old address before it was going to that PO box. Now we need to redirect it and forward it to the new address that the person provided. All right. Moving further to Jackie Vasquez, my green card, nunca. Okay, so if anybody's watching this, I'm not gonna do anything here. I'm not. Nunca lo puedo reemplazar otro. I'm not even sure if it's Spanish. So if you can translate, if anybody's watching this video and you can translate, please respond to Jackie with the translation. I'm not gonna touch any of this because I want to keep her on my comments wall so that if somebody translates it, I can address it in the next volume and answer her question. Please, that would be really, really helpful. Unfortunately, I'm not bilingual in Spanish. Would be nice, but I'm not. And hopefully, eventually, maybe I will be able to find someone who is bilingual in Spanish, and maybe we can do videos. I don't know. We'll see, but I definitely do need to address that. All right, let's move on to the next question from Freewot Demisi. Definitely mispronounced that. I'm very sorry. I have a resettlement process that started 2018. Both me and my son have finished DNA test. We have submitted all the documents, but until now it's called pending. There is no activity. What should we do? Okay, Freewot, if you could please follow up with a comment, again posted as a separate comment. Do not respond to my reply. That would be very, very helpful, because right now I don't even know which is this I-130 petition. And if it is I-130 petition, which categories? Because that's really what I need in order to look up the dates, look up the categories on the graphs that are available from Visa Bulletin, if it's even applicable, if it's even the I-130 case. So please let me know a little bit more details, and I will be able to address it in my future, in my next volume. All right, let's move on to Eric Dorn. I'm waiting from 2017 and nothing changed, because priority is only for who just arrived and applied new case. And new people comes. It's not 150 days right now. It's 365. Eric Dorn, there you go. That's another example, unfortunately, for very, very unfair treatment whenever it comes to the asylum cases from way back and the asylum cases that are being filed now. Like I said, the asylum cases that are being filed as of today, they take just a couple months to be processed, with the interview, with everything. And unfortunately, for people who've been waiting for years now, like Eric, look, since 2017, that's 6 years. 6 years. And nothing is moving along. Because why? Because the priority is given to the new cases. It's really unfair. It's really bad. So Eric, again, the only thing that I can recommend to you and people like you who are still waiting, just fight back. Just send the request to expedite, complaints, send requests to the senator's office. I mean, this is an urgent matter. This is asylum case that we're talking about. These are the people that are running away from persecution. It's not just something like, oh yeah, I came here, I want to work in the United States because, my economical situation could be better. This is not the case. This is serious stuff. And also, whenever it comes to 150 days and 365 days, I'm not sure exactly what you're referring to, because 150 days is the EAD clock, basically employment authorization clock. But if you could clarify that as well in your response comment, I would really, really appreciate it. But thank you for your comment, and I really hope that, this issue in general would be addressed soon by Department of Homeland Security, because it's bad. It's really bad. All right, let's move on to probably our last comment for today. We're already getting to a 30-minute mark from GH Fardi. Hello, sir. Thank you to reply. You're very welcome. Thank you for all your questions, and thank you for watching the videos. You told me more 2 years waiting time, my immigration file F4 category, February 2008. Okay, so visa bulletin we're going to open up. So F4 category is the brothers and sisters of adult US citizens. And he submitted his petition in 2008. Right now, the petitions that are being processed are from December 2007, and he submitted in 2008. So he's about a year behind. So about a year more waiting for GH Faridi. Already wait 15 years. Yep, it's a 16-year delay for the F4 category, unfortunately. I have 4 children, 1 married and second one son, age is over 21. What can I do to children and actually correct time? Please tell me. Okay, Faridi, please clarify what you mean by correcting time. Also, whenever it comes to children, have you already filed a petition for your children? Because F4 category is for brothers and sisters, all right? So have you already started a petition for your children? Are you also, what would be really helpful for me to know? If you're the petitioner or if you are the beneficiary, that would be helpful. Because, if you are a petitioner yourself and you're petitioning for your brother or sister, F4 category that you mentioned, right? Then obviously you can petition for your children as well. And that's what I really want to know, if you have already started the petition for your children. Because if you have, 4 children, right? If one is married and second son age is over 21. So in that case, if you're a US citizen, if you have the F4 category, then they're going to be falling under, let's see, so it's going to be category F1 for unmarried sons and daughters of US citizens over 21. I don't know why they didn't put over 21 over here. It's just confusing. But it is over 21. And also the F3 category, which is a third priority category for married sons and daughters of US citizens. So one of your kids is going to be in the F3 and one of your kids is going to be in F1. Definitely, if you did not submit the petition yet, I definitely recommend doing it as soon as possible, because it's very important. It takes time, even for kids of US citizens. It takes quite a lot of time, which also is ridiculous, and it's another reason why I keep, bringing it up. That's, if you look at the visa bulletin, and if you haven't seen the video that I've made specifically on visa bulletin, understanding visa bulletin, check it out. There I talk about the visa backlog, why this visa backlog exists, and how big of a problem it is, how unfair some of these categories are. So if you haven't seen that video, check it out. All right, so let's do the very last comment today from Miriam Art. Actually, I might do another video going through your questions, volume 33. Later today or tomorrow, we will see. I try to get it if I have enough time, because I do get more and more comments and questions. So if I cannot get to your comments or questions on time, I'm very sorry about that, but I try to do it as much as possible. All right, so Miriam R, the very last comment, minute 7, the person without taxes, sometimes people don't work, they rely on financial assistance from the government, therefore they don't do taxes. If that is their case, they will need a sponsor. That is just my thought. Miriam, great point. Actually, really, really good point. And I even know which specifically comment that you're referring to, because I had a question from a guy who who said he's filing the petition, but he never filed taxes and he doesn't have a way to prove the taxes. So Miriam, really good point. Whenever it comes to government assistance, even if it is government assistance, you will still get the tax forms from the government saying, hey, this is how much money we have given you in the government assistance. All right. This is the form that you will have to go, like for example, with the unemployment. I think it's 1099-G for the unemployment, right? But whatever it is kind of stuff that you're getting, even if it's government assistance, you will get those tax forms and you still have to file those taxes. And honestly, even if you didn't get the anything from the government, and let's say you have been, you still are in the country. All right. If you're a resident or if you're a citizen, you are still in the United States and you have to somehow live in the United States. You can't just, if you're getting the government assistance, you will definitely have the tax forms. If you're not getting the government assistance, then you're doing something in order to survive. You're finding money somehow, somewhere. This is the stuff that you have to report every single year. And that's why I do sometimes videos on taxes, because you would think, how is taxes related to the immigration? Once you start getting into these family petitions, once you start getting into naturalization especially, you will see how important those tax returns are. They are extremely important. All right. So Miriam is definitely correct. You will definitely you're definitely going to need to have another sponsor, a joint sponsor. But here's the thing. NVC, USCIS, well, USCIS, they don't really deal that much with the tax returns, but the NVC, they definitely will ask you for the tax returns and say, hey, even if you didn't, even if you didn't work officially, you still should have had some kind of income because you're living in the United States. You can't live here without some kind of income. And that income you have to show each year on the taxes. So it goes both ways. Yes, you might not have income, but you still have to file the taxes every year. And in these petitions, it really is a must-have. So make sure you stay on top of your taxes. I'm gonna put this here because in these petitions, they're extremely important. So we're gonna end the video here, and the rest I will address in the volume. We'll have to think it's going to be volume 33. As always, thank you very much for watching. Thank you for sticking around. I always appreciate your time. God bless, and I will see you in the next video.